Allora, buongiorno a tutti, grazie a tutti per essere venuti, per essere qua, a casa vostra, Camerun invece, thanks for having arrived today, here in the morning. I understand it's the last day of the course of this highly reputed Certificate of International Commercial Investment Arbitration. It has become already a tradition that the final lecture and the final event takes place here at UNIDROIT in collaboration with Roma Tre, with, I don't want to forget anyone, with the Italian Arbitration Association, the International Chamber of Commerce, the Italian chapter of that, and the Arbitration Chamber of Milan. I have not forgotten anyone. So this is the 6th edition, and it is the 2nd edition. I must say, if I'm not mistaken, this was probably not the first, second event I acted in public when I arrived in August last year. So it has become, I have a special affection for this event and for this course, and naturally for the people that are involved in it, because it I'm a very sentimental person, so this has become a very sentimental event for me. I must say that it is especially sentimental for me this year, provided that it's also has also been kindly advertised as a tribute to our late president, Professor Alberto Mazzoni, a great president of UNIDROIT and a very good friend of all of us. I know a person, an arbitrator himself, and a person very much related with the world of arbitration. We had a very nice event 2 days ago here. It was the introduction of the presentation of his last work together with Professor Mazzoni, who is also here on international commercial law. So this is only adds up to the series of events and the tributes that he is receiving most deservedly. So thank you also for remembering our president and good friends of yours. The occasion, last year we welcomed a international arbitrator and very important British lawyer, Mr. Bleak, was his name, Rishi. He delivered an incredible presentation. He was also very candid and quite critical with the work of UNIDROIT. And as I said then, I welcomed that very much. This is especially the library, but the institution generally is the temple of wisdom, at least that's what we would like it to be. And therefore, we are very much open to critical considerations. I, of course, utterly disagreed with pretty much everything he said, but that's unimportant. What matters is that there is a debate. So we enjoyed that very much. I am absolutely convinced that this year's presentation is going to be even better than that. The topic, globalization, deconstruction, and reformulation of investors' arbitration, is going to be introduced later, so I won't say more about it. Just about the topic, the speaker, of course, a world-class speaker, as this event has accustomed us to bring. And the topic is very suited to the work of UNIDROIT. Why? Because not only because it incorporates to the debate aspects related to one of our flagship instruments, the Principles of International Commercial Contracts, one of our favorite babies, but also because it is a state relation between international arbitration, state arbitration, and state disputes, or the litigation with states, provided that they have breached bilateral and multilateral investment treaties, is extremely important for us, because what we do mainly is provide best practices, model laws, and rules and treaties that concern cross-border litigation, cross-border insolvency, cross-border commercial activities and transactions. And therefore, a system where disputes can be solved adequately underpins the effective implementation of our instruments. So without this part, our instruments will be just a beautiful amount of words, completely useless. So what our main speaker, Mr. Martinez Fraga, has to say is of the most interest to us, and we are hopeful that perhaps this presentation can also be published somewhere and it's made public, because these type of instruments are very, very important, very necessary. So, but I leave the floor now to Professor Zoppini. For that, I would also like to thank the soul behind this event, which is Professor Zoppini himself, Professor Rojas Algueta, and Domenico Di Pietro, as well as Beatrice Deli, who also participated here actively with us as a good friend of the house. So thank you so much. Thank you to the institutions you represent, and thank you for being here. The floor is yours.
Thank you very much. Thanks, ladies and gentlemen. Good morning. We are now at the 6th edition of the annual International Arbitration Lecture, which is organized jointly by UNIDROIT and Roma Tre. And as I said last year, now we can see that we set a tradition, and I would say in Italian academic and practical experience, this is the lecture on international arbitration that yearly is organized, and in this occasion we really have the chance to hear the most prominent scholar and practitioner on international arbitration. As said, this year we devoted this lecture to the memory of Alberto Mazzoni. And let me tell you that Alberto Mazzoni was a very good friend and a prominent scholar. He wrote seminal articles on corporate laws, particularly on board of directors. I want to recall one of his last articles on related parties transaction. And let me tell something about him, because I always had a great consideration of Alberto. In academic relations, it's normal that first you read something written by a colleague, then you meet him. And many years ago, I read an article on cooperatives written by Alberto, and I was really impressed by his capacity of writing something so original on a theme that some corporate lawyers think not very fascinating as cooperative law. So it was my pleasure then to meet him, and we had a really good relation. He was also, of course, a very important lawyer and also very active in arbitration. But Alberto, as said, was a very good friend of this event. From the very first edition, he ensured the hospitality of UNIDROIT, and we are here thanks to him. So, as said, we are at the 6th edition. Let me just recall the past speakers. We had among our speakers Lawrence Shore. He delivered his speech on contract interpretation in international arbitration. Then Ugo Draetta, we discussed the transnational procedural rules. Then again, Pietro Bernardini, with whom we examined the issue of the finality of arbitral awards. With Yves Derem delivered a lecture on mandatory rules in international arbitration, and the last conference was held by John Beachy, and we he gave a lecture on the use of UNIDROIT Principles in international commercial contracts. As said, this year we have a great pleasure to welcome Pedro Martinez Fraga. Pedro is partner at Bryan Cave Layton, and he is co-leader of the firm's international arbitration team. He has a huge experience in arbitral disputes under the most important institutions, ICSID, ECC, and I was very struck. I told him that he is active also in Hong Kong International Arbitration Center, which is, a sort of a weird place, at least for me, to practice arbitration, but also in my experience, I realized that sometimes you have to go to Hong Kong to solve some problems. In this last regard, Pedro is also a World Bank arbitrator, and in December 2015 he was appointed by Barack Obama, the President of US, as one of the 4 US delegate members to the panel of conciliators of the International Center for Settlement of Investment Disputes of the World Bank, thus becoming the first Hispanic to have been so appointed in the history of the Washington Convention of the 1965, which is well known as the candidate round. Pedro, let me add something about him. He's also a very prominent scholar. He's very active in teaching, particularly in private international law. And in this occasion, I had a chance to read his article on apportionment of jurisdictions. And I fully agree with this point. I make a very short comment, but his point is that basically the transformation of national state is strictly connected to the evolution of jurisdiction. So basically, the model of jurisdiction in the traditional state is now overcome, and of course, a cooperation between public and private jurisdiction enforcement is fundamental in today's international commerce. Today, Pedro will deliver a lecture on globalization, deconstruction, and reformulation of investor-state arbitration within the rubric of the UNIDROIT Principles, a Conceptual Journey. So it's a very challenging theme, and some of us are active in state arbitration too. So surely Pedro Martinez Fraga will cover the best way this topic. So without further ado, I give him the floor. Thank you very much, Pedro.
Thank you so much, Professor, for that very, very generous introduction. I have 2 words before we begin. One is a word of gratitude, and the second is a word of remembrance. I would like to express gratitude, first of all, of course, to the Secretary General, Professor Ignacio Tirado of UNIDROIT. And I need to express much consideration and appreciation to Professor Andrea Zoppini, for inviting me to deliver this 6th annual arbitration lecture. I'm also grateful to distinguished members of both of these venerable institutions, Professors Anna Veneziano, Maria Beatrice Deli, Giacomo Roja, and Domenico Di Pietro for organizing this wonderful event. And it's a wonderful event, literally, because it's an event full of wonder. It is really an event where the Academy thrives in discussing issues, understanding that what is most important is the question and not the answer, not the conclusion, but the reasoning that takes you to that conclusion. And we cannot be sufficiently thankful and appreciative to them for helping us and inviting us into this type of journey. Now, I said I had 2 words. The second word is remembrance. I am particularly honored and humbled to be delivering this lecture, which is the first lecture in memory of Professor Alberto Mazzoni. Certainly you don't need me to remind you what loss of an extraordinary human being this has meant to us. He was an enlightened academic and certainly a most brilliant lawyer. Perhaps you forget, but he traveled to the United States with considerable regularity, in part as being the Italian representative to UNIDROIT. And I can assure you that on that side of the Atlantic, he is equally missed as well. I ask that we please remember him and try to emulate him. And we can do this by just attempting to be kind and hardworking and gracious and generous as he was. And even if we're 5% there, that is the best way of paying tribute to this remarkable man. Would I like to take this opportunity to express my sympathy and my true feelings of condolences to his family, friends, and colleagues. Now let's get to work. I want you to move away from the title of the lecture. It's too complicated. This is what the lecture is about, I'll tell you right now. The lecture is about thinking and rethinking the substantive standards of protection in public international law, in the public international law of foreign investment protection. And what I have to say is that the way we're thinking about them now simply does not work. And it doesn't work for many reasons, but I'm going to be very, very narrow in pointing out these reasons to you. I'm going to point to some structural deficits, but the suggestion will be that we have to live with the structural deficits. And the question will become, how can we have substantive standards of protection that can overcome these structural deficits? I will use in this journey that we'll take together one common example. It will be something very, very simple and known to you, but I will not disclose it now. It'll be a surprise when we get to it. I want to start this journey by reminding you of the words of an English poet who said and wrote, "Let us be true to one another, for the world which seems to be lie before us like a land of dreams, so various, so beautiful, so new, hath really neither joy, nor love, nor light, nor certitude, nor peace, nor help from pain, for we are here as in a darkling plain swept by confused alarms of struggle and flight, where ignorant armies clash by night." The poet speaks of a seemingly beautiful and flawless world, only to invite a deeper and more rigorous scrutiny. That scrutiny leads to the conclusion that the world appears as a land of dreams and seemingly various, beautiful, and new, and is anything but those things. In fact, he describes uncertainty and lack of transparency that lead to a darkling plain swept by confused alarms of struggle and flight, where ignorant armies clash by night. The reference to the ignorant armies clashing at night, of course, takes us back to the Peloponnesian War, where the Greeks and the Spartans slaughtered each other under cover of night. It is what we today euphemistically refer to as friendly fire. The universe and constellation of bilateral investment treaties, BITs, is no different from the poet's description of the world. At first glance, the more than 3,000 bilateral and multilateral BITs and trade protection agreements appear to constitute a perfectly ordered universe, giving rise to a treaty constellation network that is flawless, only to the extent that all things human, of course, may have debilities. Hardly is this the case. Note the following 11 propositions. First, the treaties contain similar but also different terminology, substantive and procedural protection standards. Second, even where terminology is identical, the terms often have different meanings depending on their placement. Third, there's no uniform methodology that normatively compels a monolithic interpretation, even with respect to the specific placement of terms. Fourth, the terms have different meanings because the BIDs and trade protection agreements are not centralized. Fifth, the terms have different meanings even when they are the same because each treaty was individually negotiated and is a product of its unique historical moment and corresponding agenda. Sixth, the standards of investment protection differ despite having identical language because the objectives of the parties to the BIDs and treaties collectively and individually are different with respect to export states and host states, also referred to as capital exporting states and capital importing states. The treaties claim to be bilateral, as in bilateral investment treaties, but in reality, are they little more than just bilateral agreements to act unilaterally. In addition to having different objectives depending on the contracting and negotiating states and their respective needs and expectations, the ever-critical treaty negotiating dynamic differs depending on whether the contracting parties are, first, conventional or orthodox exporting state, industrialized and importing state, economy in transition. Two, both importing and exporting state and counterparty that also is an importing, exporting state. Or three, importing states as parties or any other combination. Moreover, in many instances, these classifications are becoming progressively more difficult and inaccurate to support existing phenomena. We see countries that are both capital importing and capital exporting. China's a perfect example, so too is India. Many countries in Latin America are beginning to fall within this model. Eighth, the BIDs differ generationally, further diminishing any likelihood for universality and uniformity. Ninth, the substantive principles comprising the BIDs arise from different doctrinal spaces of international law, such as customary international law, conventional international law, public international law for the protection of aliens, international commercial law, the public international law of investment protection, and of course, the unintentional cross-pollination between international trade law and the international law of foreign investment protection. 10th, the ad hoc tribunals generating awards from investor-state arbitrations only give rise to awards that understandably are only persuasive and not binding. 11th, further contributing to the disorderly nature of this firmament is the wholesale and often inexplicable workings of most favored nation clauses and umbrella clauses. In fact, the most foundational assumption on which the entire firmament of bilateral investment treaties rests itself is less than clear. You may recall, of course, that the most important aspect of bilateral investment treaties is the economic promise that bilateral investment treaties and multilateral investment treaties or trade treaties with investment protection agendas promote and create foreign direct investment, what I call FDI. As of this date, and think about this, there are 18 studies that claim statistically significant findings as to the hypothesis that bilateral or multilateral investment treaties support foreign direct investment. When read with care, however, hardly are the studies reconcilable, let alone conclusive. 3 of these studies conclude that only some investment treaties increase FDI. 2 additional studies report ostensibly contradictory findings. One, that only US BIDs increase co-signatories' FDI. Another study asserts that most BIDs increase FDI, but US BIDs do not increase co-signatories' FDI from the United States. 2 additional studies find that, quote, only minor and secondary, close quote, and quote, slight, close quote, relationship between investment treaties and FDI is at all discernible. 6 studies reject the hypothesis that investment treaties increase FDI. Moreover, there are methodological problems present in all of these studies. These structural debilities can still lead to uniformity, transparency, and to an application of treaty standards of protection applicable to foreign investments that efficiently and justly reconcile the competing interests of capital exporting and capital importing states. But currently, these standards cannot overcome these structural challenges because of a more pressing and therefore immediately substantive challenge. It is here that I invite you to consider that uncertainty plagues the investor-state arbitral awards concerned with the application of treaty-based standards of protection to particular disputes, because public international law treaty-based standards of protection are analyzed in the context of causation liability rules of national domestic law, property rules of national domestic law, and in keeping with a historicity pursuant to which, understandably, capital exporting states frame the issues to be addressed in the workings of treaty-based substantive protection standards. Liability rules, I mean by that, rules based on causation paradigms. And property rules we can address as rules concerning the inalienability of rights in property or a person's ability to govern, own, or control property, were not designed to identify specific instances where a state committed irregularities in the exercise of its regulatory, executive, legislative, or even judicial sovereignty. These rules of national domestic contract, property, and tort law, the law of negligence and personal responsibility, simply are not enough. They cannot explain why it is that a state exercising its regulatory sovereignty committed an excess, or if alternatively, a state in exercising its regulatory sovereignty merely undertook existential acts that it needs to take in order to continue functioning as a state. National-based law concerning property, contract, and tort cannot by itself explain what and when state action is compensable. I repeat, it cannot identify when state action is compensable for one solitary but important reason. It was not designed to identify when state action is compensable. I submit to you that because public international investment protection standards have been disproportionately contaminated conceptually with the national domestic law rules of property, contract, and tort, the adjudicative process of investor-state arbitration has been adversely compromised. It can no longer compensate for the structural uncertainty that we have very briefly mentioned here. I further submit to you that for this reason, except for extreme cases, such as, for example, clear abuse on the part of the sovereignty or a case that's filed in absolute frivolity, all of the middle decisions, all of the decisions in the middle can all be statistically, mathematically predicted. And the answer is very, very simple, because the adjudicative process ultimately is not merits-based. It is based on other considerations, but it cannot be merits-based because the conceptual rubric that actually would adjudicate the pure merits is not there. Instead, the way it's adjudicated is based on pure causation and the attribution of fault on diminution of value, and therefore this is a paradigm that cannot and will not ever be severed from a domestic law configuration that does not take into account the objectives, policies, and workings of public international law. Let me ask you something. Have you ever thought about the reason why the much vaunted Republic of Argentina investor-state arbitration cases, 1, arising from a single issue, 2, concerning the identical or similar fact pattern, 3, occurring close in time, 4, with similar or identical expert testimony, 5, involving similar, if not identical, underlying transactions, and 6, because time is linear, each tribunal having the benefit of its predecessor. Why these cases have been decided differently? The range of awards has varied from having the same finding to diametrically opposed finding to clearly compromised awards somewhere in the middle, negotiated at what is obviously a midpoint. 3 results that are not merits-based, but they are statistically predictable. In other words, if we take all the Argentina cases, a person with just simple mathematics, about 5th, 6th grade level, can, maybe a little more, can predict which ones are going to be, how many, not which, but how many are going to win, lose, and how many are going to be likely fall into a category of midpoint negotiated decisions. The reason is simple. The adjudicative process is simply not conceptually geared toward merits determination. Have you also noticed that these differences extend both to liability and to damages? When national domestic rules of property, tort, and contract are applied to the public international law of investment protection, the merits simply do not matter because the cases are decided on grounds other than those actually crafted to identify instances where a state has exceeded its regulatory, executive, legislative, or judicial sovereignty. The conceptual deficits arising from the primacy of national domestic law, together with the inordinate influence of capital exporting states, can only be explained with rigor by analyzing a very, very concrete example. I have selected the simplest and most immediate of principles, and it is here that I had a surprise for you, you may recall. I said I picked the concept that I will apply here for your working knowledge, but I'm not going to tell you what it is. I'm going to surprise you with it. I picked something that I thought would be very simple and very universal and very close to UNIDROIT too, because it's a subject that appears in the UNIDROIT Principles of International Commercial Contracts in Article 10.2 and 10.3 as well. I've picked prescription, the limitations doctrine, to which I refer to as LPD. The issue is known to all of us, it is readily at hand, and for this reason, it should be simple. In fact, if one were to ask the simple question, does the public international law of foreign investment protection recognize a limitations doctrine? There would be 4 answers to this question. Yes, no, maybe, and it depends. Now, this is startling that there will be 4 answers seemingly contradicting each other. But there's something even worse. All 4 answers are technically correct. Let's see how this can be looked at with even more rigor. The first generation of bids, i.e. bids executed between 1959 and December 31, 1993, are largely the product of writings that, with respect to the LPD, do not at all distinguish between national, domestic, and international law, the aspirations of capital exporting states regarding international investment. The failure evidenced by 563 bids lacking a limitations period finds its origins in these 2 propositions. In other words, in the first generation of bilateral investment treaties, there are a total of 563 bilateral investment treaties. Not one has a limitations period. Now, you can take several positions here. You could say, well, gee, 563 times 2 sets of negotiating teams from 2 countries forgot. You can take that position. Or you can say the teams that were leading this effort were sufficiently strategic to leave out the limitations period. Why? Because those teams represented a geopolitical interest that wanted the most expansive limitations period possible. And you can choose, there's no answer, This is not written anywhere, but you can use your intellects to formulate which of the two scenarios, or perhaps even a third, you believe to be best. The second generation of bids, executed as of 1994, and will be sloppy and call it 1994 to the present, does not contribute to bringing uniformity, certainty, and security to the law of investment protection. The contrary is true. From 1994 through the present, 1,881 bids have been executed. By one count, 1,498 entered into force. And of this 1,498 bids, only 106 have a limitations period. Only 106. Thus, 1,392 bids that came into force between 1994 and the present have no limitations period. Furthermore, the 106 bids containing a limitations period have different limitations terms for identical standards of protection. This configuration is not conducive to certainty and security. Investor-state arbitral disputes arising from 1,392 bids that are currently in force and lack limitations period invite inconsistent rulings on identical legal and factual issues. This serious problem is made worse because rulings on the application of a limitations period tend to be case dispositive, as all of us know. Such rulings under the current international law regime concerning the LPD tend to be all or nothing propositions because the doctrine of proportionality plays no role in contemporary LPD analysis. Therefore, tribunals are left with no uniform and common standard by which to undertake an LPD analysis that may maximize the likelihood of uniformity and therefore security and certainty. Cases arising under the remaining bids that have limitations period are regrettably no more promising. These bids have different limitations period attaching to identical standards of protection. They range between 2 and 5 years. Moreover, the 2 to 5 year time frame on these limitations period may lead to relatively uniform results, but for the wrong reason. These limitations period were mechanically imported from national domestic law, and if you study, for example, the limitations period, the 3 year limitations period of the NAFTA, you can see exactly how it was that it was taken directly from the law of Toronto, Canada, and just placed in the NAFTA without any consideration of what the NAFTA was all about and what the underlying policies of the NAFTA were or sought to further. Consequently, the limitations period attaching to standards of protection are no different from those that govern national domestic contract property and negligence claim between private individuals. These premises are fundamentally flawed and command revision. Now, non-treaty pronouncements in the form of judicial decisions, arbitral awards, and the rulings of claims of tribunals best describe, if not altogether constitute, the normative elements of customary international law. The theoretical constitution and practical application of the LPD in public international law that has influenced the doctrine's role in international law of investment protection can be gleaned from a handful of landmark pronouncements on the issue, all of which took place during a 20-year period of time between 1885 and 1905. This jurisprudence offers a unique perspective because its treatment of the LPD is not based on a limitations period contained in a treaty. Therefore, they represent copaceptic paradigms of claims tribunals addressing the issues of limitations free from the conceptual shackles of any single treaty. The Gentilly case, a story told and retold, does not compel a lengthy factual recitation. The case concerned claims against Venezuela brought by the Italian government on behalf of an Italian citizen alleging payment of a debt that had accrued 30 years earlier. The case was filed with the Permanent Court of Arbitration pursuant to the Italian-Venezuelan Mixed Claims Commission, constituted under the protocols of February 13 and May 7, 1903.
The case is particularly rich in canvassing the arguments of the commissioners for the parties, counsel presenting the respective cases. The umpire reviewed a fairly comprehensive spectrum of writings of commentators and so-called precedent, purporting to address the role, if any, of the LPD in international law. The umpire denied the claim as stale, as we may imagine, but not before articulating his own exegesis as to 4 separate but equally binding sources that, in the umpire's opinion, invited the claim's dismissal. Here I again remind you, what is always critical is the how and not the what, the why and not the conclusion. First, the umpire sought to distinguish Venezuela's defense in Gentilly from Mexico's defense in the Pious Fund case, which was earlier decided by the PCA. The umpire distinguished Pious Fund by emphasizing that the tribunal in that case was addressing domestic rules and not principles of law, noting that, quote, the Permanent Court of Arbitration never denied the principle of prescription, a principle well recognized in international law, and it is fair to believe that it would never do so, end of citation. The umpire added, quote, such denials tends to upset all government since power over fixed areas depends upon possession, sanctified by prescription, although the circumstances of its origin and the time it must run may vary with each case, period, end of citation. This very formal argument that cherry-picked a single sentence from the totality of the Pious Fund opinion in an effort to reach a diametrically opposed holding was understandably buttressed by extensive reliance on the works of publicists dating back to Grotius and Vico. The umpire struggled articulating the proposition that somehow the LPD had a cognizable space in international law, and the application of that principle, particularly in the wake of the Pious Fund ruling. Second, the dismissals of the defenses were premised on precedent, where claims tribunals had dismissed stale claims. Notably, none of the authority on which the umpire premised his findings sought to distinguish between the application of the doctrine under international law and its workings in national domestic law settings. To the contrary, the umpire, citing to Barbier versus Venezuela, the authority most extensively relied on in the opinion, selected language from that ruling that emphasized national domestic law should serve as a guidepost in the application of the doctrine in an international context. Let me share it with you. This is what he wrote, quote, a stale claim does not become any less so because it happens to be an international one. And this tribunal, in dealing with it, cannot escape the obligation of a universally recognized principle, simply because there happens to be no code of positive law by which its action is to be, end of citation. Thus, the use of this authority further weakens Pious Fund's gravitational pull on Gentilly. Third, the umpire found national domestic law, even that of non-party jurisdictions, helpful in this case. Citing to the courts of equity in England and the United States, in particular to Bouvier, the umpire referenced how, quote, courts of equity, though not within the terms of the statute, have nevertheless uniformly conformed to its spirit and have, as a general rule, been governed by its provisions, unless special circumstances of fraud or the like require in the interest of justice that they should be disregarded. Courts of equity will apply the statute by analogy, and in cases of concurrent jurisdiction, they are bound by the statutes which govern actions at law. Some claims not barred by the statute, a court of equity will not enforce because of public policy and the difficulty of doing full justice when the transaction is obscured by lapse of time and loss of evidence. This term is the doctrine of laches, end of citation. The third source, national courts applying equity, is closely related to but still distinct from the four premises upon which the dismissal of the claim rested. An equity-based argument derived from a very particular understanding of justice and the ethics attaching to LPD. By way of example, The umpire mentioned how, quote, it thus appears that courts of equity, even when not bound by the statute recognizing its essential justice, had followed it, application of the LPD, in spirit, end of citation. In fact, beyond a perceived practical necessity, the opinion characterized the LPD as, quote, laws of universal application that were not the arbitrary acts of power, but were the outgrowth of a general feeling that equity demanded their enactment, end of citation. Accordingly, Gentilly provides historical evidence that at least claims tribunals under the auspices of the ICJ's predecessor, the PCA in 1903, identified that the applicability of a limitations period in international law arguably had its normative foundations in writings of publicists, precedent in the form of claims tribunal awards issued in conjunction with the PCA, the national domestic practice of equity courts and in England and the United States, and more general, quote, natural law-like, close quote, propositions arising from specific conceptions of justice, equity, and a purportedly shared understanding. To this extent, Gentilly can be seen as contributing to the modern understanding of the LPD, or misunderstanding, as based on national law, a sense that finality is proper, a general proposition that finality is necessary, and the ethical moral precept that it is somehow wrong or negligent for a claim not to be asserted within an unspecified and perhaps unidentifiable period of time. The Gentilly analysis paints the perfect portrait of the legacy LPD that is pervasive in the modern international law of investment protection. It is a paradigm of the doctrine premised on national domestic law principles, with intuitive components that are purely visceral, that overemphasize the policy of certainty and finality to the detriment of other considerations endemic to public international law. Also, it describes a doctrine that is materially influenced by the economic agendas of capital exporting states. By omission, the reasoning and holding in Gentilly is also eloquent as to the general issue that should underlie any consideration of the application of the doctrine in an international law context, most notably the policies incident to any particular breach of public international law. Despite the umpire's categorical reasoning and conclusion that the doctrine finds no place in international law, even where the applicable treaty is silent on the issue, the award then, albeit quite timidly, qualifies the finding by asserting that the limitations period to be applied and, quote, the circumstances of its origin in the time it must run may vary with every case. May vary with every case. Period, close quote. Ironically, and this is very interesting in the opinion, the losing arguments of counsel for Italy in Gentilly were much more progressive, clairvoyant, and relevant with respect to the development and application of an LPD in an international context. Counsel for Italy argued that policies underlying the application of the LPD in national domestic cases were not transferable to the international sphere. Let me repeat that. Application of the LPD in national domestic cases were not transferable to international law sphere. Even though counsel framed these arguments within the terms of the substantive dispute at issue in Gentilly, the overarching principle in his contention is foundationally the need to have different LPD analyses attaching to national and international rubrics, respectively. Not surprisingly, the umpire never addressed these arguments. In Williams v. Venezuela, as in Gentilly, a sovereign, in this instance the United States, brought a claim on behalf of a U.S. citizen against Venezuela, alleging monies owed. The action was filed with the American Venezuelan Commission, also as in Gentilly, under the auspices of the PCA. The uncontested record established that, quote, the claim was not brought to the attention of the Venezuelan government until 26 years after its inception. End of citation. The issue before the Claims Commission was framed in two sentences, whether, quote, by lapse of time, the means of defense have been impaired, and there is total want of excuse for the long delay by claimant. Under such circumstances, what does the law require at our hands? End of citation. In doing so, the tribunal observed that, quote, beyond the requirement that its decision must be accorded to justice, the treaty furnishes no guide to the Commission regarding the operation of the lapse of time in extinguishing obligations. It is left to the direction of international law on the subject. Does it recognize the doctrine of such extinguishment as between states in controversies like this? End of quotation, so it asked. The Claims Commission answered the second query in the affirmative. It therefore follows, with respect to the previous question, that dismissal of the claim was warranted. The Williams case finds that international law provides for a limitations period even in the absence of a treaty containing any limitations qualification based on two sources. First, the writings of commentators, and second, the domestic common law of the United States. In fact, virtually the entire body of Commissioner Little's award is comprised by single paragraph summaries of the writings of jurists on the subject of the LPD, tracing the contours of 4 centuries of writings on the issue. After synthesizing these writings, the Commissioner concluded that, quote, on careful consideration of the authorities on the subject, much of whose discussion is only remotely applicable to the question as it is presented to us, we are of the opinion that their decided weight, we might say, by very necessity, prescription has a place in the international system, and it is to be regarded in these adjudications. End of citation. Quite remarkably, the Claims Commission further qualified its conclusion by noting that these principles recognized in the writings are, quote, general, close quote, and therefore at least presumably at first glance, not applicable, quote, to individual claims or debts by one state on account of transactions with citizens of another state, period, end of citation. Although aware of this basic conceptual challenge, the Commissioner reconciles it for purposes of the award and disavows the claim on the ground that limitations are grounded in natural law, a formulation that pervades the writings of virtually all jurists cited in the award. The Williams Award served as a conceptual foundation for the Gentilly analysis and holding. The two opinions import domestic and natural law into their international law analyses of the LPD. In either case, did the Commissioner or the umpire look to international law itself for a response to its fundamental query? The answer is no. Does international law recognize the LPD in circumstances where the treaty at issue contains no such qualification? Rather, the analyses focused on national law and commentaries premised mostly on a natural law conceptualization of the doctrine. Other claims tribunal cases between 1885 and 1905 applied an identical methodology. This is paradoxical. The Gentilly and Williams can be construed as proposing that international law, without specifying a particular field, recognizes and encourages the application of the LPD even where the treaty at issue does not prescribe a limitations period. The contribution of the workings of the LPD in international law arise from these cases influenced the lack of uniformity currently configuring the status of an LPD in public international law generally, and with respect to the international law of investment protection in particular. Closer reflection is necessary. The claims tribunal cases extracted from the writings of jurists that the LPD is virtually sacrosanct because it makes possible security and certainty through finality. The argument was expanded to say that this security and certainty would also avoid territorial disputes among nations, as well as contribute to the stability of commercial transactions. With respect to this latter point, it was argued that only chaos would ensue were all contracts subject to challenge, notwithstanding the passage of time, let alone capable of being rescinded. Thus, the principle of security was enshrined and accorded a dispositive weight in any calculus considering the doctrine's application. The claims tribunal cases, however, paradoxically undermined and disavowed the very principles of security and certainty that the tribunal sought to foster pursuant to the LPD. By relying on natural law without more, the claims tribunal awards contributed to a fragmented international law jurisprudence on the basic question of whether LPD at all applies to customary international law or to conventional international law when a treaty is silent on the issue. The jurisprudence based on natural law made possible the leap from domestic, national to international law, but only in general terms that failed to set limits. Consequently, the claims tribunal awards created an open-ended limitations period in national law. They prescribe the application of the LPD, but omit setting an actual limitations timeframe. In fact, the very authority and specific citation that the commissioner in Williams relied upon demonstrates the implicit shortcomings of the strict natural law analysis that was observed. Quote, and this is Tarpelli speaking, quote, hence the law of prescription, a necessary and just law by means of which society stops through certain limitations all inquisitions of ancient rights. Most reasonable is, therefore, the law of prescription in the natural order, although nature itself does not overtly establish its strict necessity, nor fix its proper limitations. This is to be performed by society as it grows more and more perfect. And it is as much the more its office as it is therefrom and therein that the social complaint requiring such a remedy takes its rise. The omission is likely attributable to two factors. First, the practical perspective, the resolution of claims that contained undisputed records of the passage of more than 2 decades, as were the issues confronting the claims tribunal, did not require the tribunal to go further and articulate a limit on the applicable limitations period. The claims tribunal were not asked to make such a pronouncement, and they understandably did not sua sponte do so. Second, the claims tribunals were to formulate a rule that would set a limit to the limitations period applicable to the case as a matter of, quote, settled international law. Under its existing legacy methodology, the claims tribunal would have to turn to national domestic law for analytical assistance. In fact, the claims tribunal did rely on national domestic law for analytical help, only to arrive at the unqualified proposition that international law recognizes the LPD. Using national domestic law to fashion a limitations rule, having an actual term of years more precipitously, would have led to the lack of uniformity and want of conceptual coherence now present in public international law on the subject. Recourse to national domestic law for formulating a terms of year to be applied to a presumably public international law rule of limitations would lead to the creation of different rules depending on the domestic national law of the state being sued. Thus, taken to its logical consequences, only out of mere statistical happenstance would a consistent limitations rule emerge. Mere statistical coincidence thus would constitute the normative foundation for uniformity in this field. The necessary analysis that would have formed a uniform system was never undertaken and has still not been addressed. It would require turning away from a national law paradigm. Such analysis would invite consideration of issues germane to the policies of public international law, which are separate and distinct from those of national domestic law, and only intersect on general matters that will be considered under any rubric. The claims tribunal cases do leave us with the rule of law stating that customary international law recognizes the LPD as applying to disputes concerning treaties that omit any reference to that doctrine. no alternative construction of this authority is possible. This proposition, however, directly and explicitly conflicts with contemporary arbitral awards arising from investor-state arbitrations. These arbitral awards hold that customary international law does not recognize the LPD and further state that such a doctrine only forms part of conventional international law when the treaty at issue contains a limitations clause. These conflicting statements can perhaps be reconciled, by noting that the arbitral awards concern the public international law of investment protection, while the writings of publicists in the claims tribunal cases make no such qualification. In fact, it may be asserted that the claims tribunal cases mostly either address territorial disputes or conflicts arising from commercially based transactions that do not at all address investment protection standards. Sounds like a likely argument, but really it's not. Despite its surface appeal, this explanation is belied by the arbitral awards themselves. These awards hold that the LPD finds no space in customary international law generally. The arbitral awards addressing the LPD do not distinguish between customary international law, and the international law of investment protection. Therefore, the arbitral awards cannot be reconciled with the claims tribunal cases on that basis. The problem is more complex, and so too is its solution. In a claim, for example, arising under the Lithuania-Italy bid, the tribunal rejected respondents' limitations defense, observing that, quote, contrary to the respondent's assertion, the claimant's claim is not subject to the Lithuanian statute of limitations. In accordance with the agreement, the tribunal applies international law, not Lithuanian law, to these proceedings, and there is no deadline prescribed by the agreement, rules, or general principles of international law. End of citation. Moreover, in that case, the tribunal held that it was reasonable for the claimant to have waited to initiate any arbitration until litigation before the courts of Lithuania concerning the privatization at issue in the arbitrations was completely concluded. The tribunal specifically noted that, quote, the claimant notified the respondent of his intention to commence arbitration as early as 2007, when the litigation in the Lithuanian courts relating to the Alita privatization was going on. It was not unreasonable, in the tribunal's view, to wait for those decisions to be rendered before undertaking a separate proceeding in an international setting, period, end of citation. Thus, the tribunal concluded that, quote, the claimant's claim was admissible, despite the passage of 26 years. Similarly, the tribunal in Gavazzi versus Romania rejected respondents' limitations defense and stated that, quote, arbitration proceedings are governed by international law. Only international law and no domestic law can introduce time bars. Neither the ICSID Convention nor the BID nor international law generally contain any statute of limitations in relation to treaty claims. Without such clear legal provisions, no time bar can operate to bar an ICSID arbitration. End of citation. This authority restates the proposition that there is no limitations period in public international law or within the ICSID Convention's framework except where present in a treaty. Also, because international law only often governs treaty-based proceedings, a respondent is foreclosed from relying on national domestic limitations period to limit the prosecution of such claims. Because of the absence of an international counterpart to a domestic limitations period within the rubric of customary international law, treaty-based claims are governed by the limitations period contained in the particular treaty at issue. This line of authority, however, cannot be reconciled with the claims tribunal cases. Therefore, the current status of the limitations period doctrine within the framework of public international law is uncertain. One line of authority, the claims tribunal cases, together with some publicists, hold that customary international law recognizes and applies LPD in disputes based on a treaty when the treaty is silent as to the limitations period. A second line of equally normative authority holds that the customary international law does not recognize the LPD in disputes based on a treaty where the treaty is silent to a limitations period. The fragmented configuration and absence of sound doctrinal underpinnings beyond reliance on national domestic law and the policies favoring the interests of capital exporting states have left tribunals to grope with makeshift formulas. Let me just say that the limitations period doctrine I have chosen, but that can also apply to the more orthodox standards of protection, fair and equitable treatment. The thinking is that the rationale using domestic law to fill in fair and equitable treatment, for example, where fair and equitable treatment starts working as a strict liability construct, does not work. Now, what have we really said is the solution? We haven't. We've just said that we have to turn away from national law as the foundation for the public international law of investment protection. By turning away, it doesn't mean to eviscerate it, but rather to incorporate it, but it has to be incorporated in support of other principles. What are these principles? The determination of elements such as macroeconomic analyses, the determination of elements such as microeconomic analysis. The use of proportionality is absolutely foundational. It cannot be an all or nothing situation. The distributive effects of an award must be taken into account. You may recall that in one of the water cases, the $350 million award was the equivalent of the Czech Republic's then entire health budget. Also, the assumption that parties to bids are in pari materia and at arm's length as in a contract needs to be revisited. All of these elements, together with the public purpose doctrine, which has to be moved from a subjective self-judging paradigm to an objective content-filled paradigm, are important. Now, I understand that this is not easy. Few things worth undertaking are. And it brings to mind one literary paradigm in the worst case situation where Oscar Wilde wrote and said that a map of the world that does not contain utopia is not worth looking at all. But in a mid-level situation, in a more reasonable horizon, this also reminds me of Ovid's Metamorphosis. And you may call that an Ovid's Metamorphosis. There's a very moving passage where Aeneas is in the underworld, and there is a cave, and in front of that cave leading to the land of the dead, there's a spirit, a gatekeeper. And Aeneas says to the spirit, I would like you, sir, to please let me go through to the underworld, that I may visit one last time my deceased father. And the spirit looks at Aeneas and says, Aeneas, you're a man of virtue, by both word and deed. Of course I will let you see your father. And he says this, because nulla via in via virtuti est. For virtue, no path is impossible. And the same applies to us here. Thank you for your generous attention.
Thank you very much, Pedro, for your conference. I think we have time for questions, so it would be it's a very good chance to ask questions.
Just thank you very much, Pedro, for this outstanding lecture. And when you started by saying that arbitral awards are not decided looking at the merits, I was thinking about what Italy is experiencing right now with the investment arbitration proceedings and the fact that we have now 3 awards out there, and they are one completely against Italy, one completely in favor of Italy, and one exactly in the midpoint that you were mentioning on very exact facts. So this, the starting point of your class is confirmed by what is happening right now. And also these cases are a good example of the complex interplay between domestic law, Italian law in this case, and international law, and this is very much discussed in these proceedings. What is the role of Italian law? So I think your lecture was, at least for an Italian public, very, very current. So thank you very much. And of course, we can take questions for Pedro, if any.
I do have a question, and maybe this. And I was really intrigued. I must say, I have the privilege of enjoying Pedro on a daily basis because we work together. So I'm the privileged recipient of thoughts and comments of this level almost every day. And it's very thought-provoking. And the one thing that I wanted to ask Pedro then, and it is difficult. And Pedro mentioned that kind of inconsistency that you will find in arbitration decisions that is somehow embedded in the system that has been adopted to settle this type of disputes. And we tend to accept that for what it is. But then you said something about utopia, and that prompted that question. Let's try and be utopistic. What would you do to bring consistency or somehow predictability in the world of investment arbitration?
Thank you for that excellent question. I think that it's very basic and very difficult, as most basic things are. In engineering, it's the laying of a foundation that takes more time. After that laying of a foundation, the building goes up rather quickly. We need objective standards. We cannot continue to have a situation where the mere diminution of value without more, for example, would be deemed to be a cause for liability. We need clear rules for liability, and we have to also start thinking of international liability, not just liability without the qualification. And in the sense of public international law, it has to be public international law liability. What does that mean? That means that this regime for liability and quantum are based on the policy needs, aspirations, and goals of public international law, not on the same rules that the grocery store manager uses to collect a debt from a neighbor. So we have to start thinking in terms of having actual objective content. Public international law talks to us about objective content. It says law and economics is relevant in this field. It says the underlying policies of the treaty are relevant in this field. It looks to quantify so that we don't have overprotection built into the protection standards. So I think this is the first step. Let's have an objective rubric. And not each case is a brand new case with new law accompanying the new facts, which is what we have. It doesn't surprise me that in 3 cases, there's a 33-33-33 split. Same thing happened with Argentina. The same thing happens when you look at all the cases. When I hear arguments that say, well, host states are upset because they say they always lose, or the system is pro-claimant, I say the numbers don't point to that at all. The numbers point to randomness. It's not pro-claimant or pro-respondent. It may be a field of law that's used so that a private entity or natural person may be able to assert a claim in the public international law sphere against a sovereign. But it doesn't favor one side over the other. For better or for worse, it's random.
Well, thank you very much, Professor Martinez Fraga, for your speech. The picture that you depicted put me in a state of despair because to some extent, much of the power is given to arbitral tribunals as lawmakers. So my question to you, if you talk about objective standards, who is to establish the objective standards? Most likely not the arbitrators themselves when they are confronted with a specific and singular dispute. So what is your view?
Excellent question of both theoretical and practical interest. The lawyers are supposed to make the standard. Let me explain how. If I'm representing a state, I will start talking about the investment, not just for purposes of going through the almost mechanical and to some extent non-challenging analysis of whether or not there's jurisdiction. Of course, that's an obligatory predicate, but think about the investment and its relationship to the purported regulatory activities in terms of the macroeconomic consequences, the microeconomic consequences, the economic consequences of proportionality, the economic consequences of alternative state action, the likelihood of alternative state action, the distributive effects. If you start couching the arguments in those terms, and also in the traditional domestic strict liability or effects test or sole effects test, whatever you want to call it, it's that too, and expectations, it's not too sophisticated, really. You also make those arguments so they understand that you know what you're talking about, but that you're trying to inform the system because you're trying to elevate the system and to create new metrics for adjudication. So who has to build it? The lawyers have to build it. The second that the lawyers start advocating in this way, that will become the normal speech of the tribunals. The tribunals will start ruling in these ways.
Thank you so much. And what kind of action do you suggest to create this fundamental? I mean, on the that's to image that you have a full power to decide and to try to suggest to the community to create something of that, like that. What are the steps, the real steps?
I think an institution like this is specifically placed and privileged to help in the formation, and transformation of these standards by having projects, by writings, by having sample protection standards, by having policies that should be considered by arbitrators in addition to the not too sophisticated elements that are now in place. So let me ask you this, just think about this for 1 second. I'm sure you know 20 practitioners, and I'm sure you know 20 academics. Ask them what the elements of fair and equitable treatment are. You're going to get 20 different answers, 40 different answers. They will overlap, but you'll have 40 different answers. All 40 will be correct. Do you think we can continue to live like this? It doesn't work. It really doesn't work. You'll have things like 33, 33, 33 all the time. So an institute like this institutions, that's the best place to start publishing towards uniform standards of form protection investment. Yes, sir.
Picking up on that point, though, the difference between the common law system and the federal system and the inquisitorial system, I would favour 33, 33, 33, because it's the arguments that prevail in that system. In an inquisitorial system, I would say maybe not. And I think what you're effectively saying is that there's a convergence of common law and civil law codes that need to occur in policy sense in order for this to happen, because you referred to the equitable maximum of large acts, for example. The dozen or so equitable maxims that are available to us, if we had them as arbitrators, would we then go to a counterpart as and say, he or she who was first in time shall prevail, or you shouldn't take advantage of your own wrong? Would that have come out in the case of
Yeah, I agree with you that what's necessary is a convergence of all the systems. That's what public international law is supposed to be. It's supposed to be precisely that convergence.
connecting to what you just said now, could it be that it's exactly this the reason why the path towards standards is slowed down? I mean, could it be that it's exactly that those principles might be recognized and have an influence at the jurisdictional and national level, can scare some countries maybe that are not ready or don't even want those principles or standards to be recognized? I mean, an influence is it's inevitable in this case. So maybe what a country cannot reach with its national history, it can reach it from upon this international level.
Sorry to ask, what do you mean about that the country would be afraid? I don't understand. Explain that to me.
Yes, in a practical meaning, if like we're recognizing about like expropriation, there are a few principles and standards about it.
Very simple, five principles.
Exactly.
Very simple. They sound the same, they're different in every expropriation.
And then there is a country which has not yet recognized all of these principles in a jurisdictional way, national way, and has to recognize them because of this international direction. And maybe the country prefers that some standards might be confused or have many options because they don't want a precise standard and objective standard to be recognized for personal interests of the country.
You know, here's it could be, I mean, and what do I know, but here's the problem. I think that in the current regime, there are no objective standards. I think host states, for example, which is the majority of the world, the United Nations recognizes 192 countries exclusive of Taiwan, Kosovo, and the Holy See, the Vatican. The majority of those countries are poor. And the majority of those countries tend to be, when you take the top 15 out, what's left is poverty. And even within the top 15, there's a big difference between number 1 and number 15, without getting into specifics. So I would think that most of the world would want to have a clear and lucid rubric rather than something that is more closely tied to a negligence standard in domestic law. And I think certainly most states, any states, would want to have the type of, I really have a 9-point analysis that I didn't get into in the interest of time, but there's a 9-point analysis of categories that it's all economically driven. Would like to have those types of analyses in order to avoid what is the obvious economic consequence of having the system that we have. The system that we have now leads obviously to a situation of overprotection. It doesn't really work.
Thank you. My question is, you've said it, there's of the totality of the nations in the world, the top 15 are the, let's call it, the richer nations, and usually that's where most of the scholarship comes from. So how would we guard up against creating this foundation and this set of principles that only serve where the majority of the scholarly product is coming from?
Well, I think that you know, maybe the majority of scholarship comes from those nations, but not the majority of scholars. But in any event, I think that academia has sufficient integrity to want the world to be better without sloganizing this conversation. And one way of looking at it is can we be mathematical and can we be precise? And have we really brought law and economics to public international law? I've got to tell you, the answer has to be absolutely not. I have not seen one well-reasoned opinion getting into law and economics. It just hasn't happened. And these subjects are extremely relevant to liability in this field, in my opinion. So I don't think that there is a contradiction necessarily because of the demographics of global wealth and the proliferation of writings from certain corners. I think that what I'm suggesting is sufficiently universal to be beyond any parochialism.
I have a question here in the topic that we touched here during the lecture. So it's limitation period and the idea of setting such objective standards. If you could propose a standard regarding this limitation period, what would you suggest in the investment arbitration? Should it be like 10 years, 20 years? What should be, in your opinion, this standard?
Interesting. You know, it's the UNIDROIT, the Principles of International Commercial Contracts has in 10.2, I think they talk about the general period is 3 years, is it? So the experts in the room 3 years? And then it talks about 10.2.2 talks about a maximum of 10 years, is that correct? 10 years? This is the UNIDROIT place, right? Okay, so yeah, and so it's 10 years. Now here's the deal. The 3-year and 5-year situation we now have doesn't work. It just it doesn't work, and it cannot work because of the nature of foreign investment relationships. It's not the time, you know, it's not the thinking of buying the grocery store around the block. Oh, it's the seller has a 3-year, you know, limitation period or whatever. That doesn't work. It has to be more. And I think that UNIDROIT has it right. I think it's after 10.2, the 10.3 analysis they have, I think is also very, very good. I think 10 years would be what I think would work and what I think would be fair because of the complexities of the investments, particularly when we're talking about sunken investments. This is extremely important. But we can't have situations where investment standards lead to overprotection because that leads to an economic model where then the host state at the end of the day really will start suffering. And then the whole premise is shaken. You know, it's already shaken enough that foreign direct investment and bilateral investment treaties, there's no direct correlation. The 18 studies are they're everywhere. They're everywhere. And it doesn't surprise me. Why are the 18 studies everywhere? Because the protection standards are everywhere. So the economics will reflect exactly what the protection standards are doing. It's none of this is, I mean, I make a living doing this, you know, investment arbitration. So I mean, I like the system and I'm a part of it. Don't get me wrong. I think it's great. But that aside, can we do better? Of course we can. Do these contradictions mean something? Of course they mean something.
Hamza from the UNIDROIT Secretariat. You talk about law and economics, and here at UNIDROIT we certainly give a lot of importance to the economic impact of any law reform that we work on. In fact, we have a project on exactly that, where we look at developing a framework to determine the economic impact of any commercial law reform project. One of you think that in a globalized world, and as we move more and more towards globalization, political differences between states would become less of relevance and significance when it comes to developing law that sort of benefits the entire world. But it's exactly the opposite sometimes. What do you think are some steps that can be taken to incentivize states to sometimes work more towards the common good rather than their own political things? You know?
If I had the answer to that question, I wouldn't be sitting here. I think I'd be in heaven. But here's what I do think. I do think that as we become more globalized, we're really moving from a model of independence to a model of interdependence. And we're leaving behind territoriality to complete non-territoriality, which means that if we have a model of interdependence, states will have less margins for purely nationalistic interest, political interest, to rule the adjudicative process. So necessity, economic necessity, shared problems, whether it's human trafficking, vertical and horizontal nuclear proliferation, global warming, these are problems, transnational corruption, these are problems that no single state can anymore handle. These are problems that we can only handle together. So the level of interdependence, the deeper we get into globalization, and globalization, whether you're for it or against it, it really doesn't matter. It's a reality. It's a reality, and we have to adapt to this reality. We have to incorporate that reality to what we're thinking. So I think that globalization will help diminish the type of nationalistic interest that may be an impediment to the very sovereign being national.
Okay. I hope you can hear my voice. No, okay. Thank you very much. First of all, I have only two considerations on the side of the work that can be undertaken by intergovernmental organizations, such as, for example, UNIDROIT in this field. In a particular field of investment arbitration, and more generally in arbitration, the intergovernmental sister organization, which has been and is still more active, is UNCITRAL. So UNCITRAL is particularly interested now in this sector and will, in all probability, will work on that. But this is so which means, of course, that there might be cooperation, but in general, we tend not to have overlapping projects in order not to sponsor states' resources. At the same time, you mentioned the UNIDROIT Principles, and I think that it was very interesting what you said. I think the UNIDROIT Principles approach to limitation period is, of course, based on commercial contracts, but it does modernize the thinking about time limitation, which means that quite apart from the length of period, which might be even considered to be not suitable for investor states arbitration, but some of the underlying ideas of the relationship between the limitation period and a cutoff period, for example. Some of the underlying ideas of how to look at suspension, interruption, and also the inception, the moment when everything begins, the interaction between subjective and objective elements. All this, I think, it's there, and it can be more than a source of inspiration, I would say, for the development of these objective standards that you are referring to.
Hi, thank you for your presentation. I have a question concerning, your proposal to look at the macroeconomics of each case, or the macroeconomic consequences of a case. I'm wondering to what extent your suggestion goes to liability and to what extent it goes to damage quantification, because it seems, to me, it seems less appealing to look at that when it comes to liability. If you are counsel for investor, it's very difficult to imagine that if you have a contract and the contract is terminated because of certain macroeconomic considerations. It seems more, I don't know, at first, the first impact would be that maybe macroeconomic considerations will play a more a fair role when it comes to quantifying damages, or whether take into account loss of profits, which sometimes can lead to incredibly huge arbitral awards, or like the damages award.
I think that these elements that I mentioned are interrelated, whether it's macro, whether it's distributive effects, whether it's proportionality. Proportionality means precisely, what would have been the cost of a corrective measure other than the one that was actually implemented. But I think that with respect to macroeconomics in particular, it could go, depending on how you're using it, to both liability and damages. Certainly one way of understanding, if there's one place where we find that some objective metrics by necessity has been foisted into it, and I think it's a very good thing, is the necessity defense for states. The necessity defense does bring up microeconomic issues that are extremely important and viable, and that have been translated into liability and damages. And in fact, in a book that I will write, if I live long enough, is I will use that section as the actual point of departure that exists where we already have done this, so that it's not really reinventing the wheel.
Thank you for your presentation. I was wondering, since some international actors might not be willing to move towards interdependence, and they cherish that territorial approach because it is more suitable to their own interests, how can we really raise their interest towards this interdependence that now seems the world of utopia?
Thank you. That question was raised in a different way by someone. Again, if the briefs and the memorials, if the conversation is set with the rules of engagement that you control as a lawyer, then the tribunal has no choice but to follow what you've done. You know, at the end of the day, this thing that we call arbitration is really finding equipoise between party autonomy and arbitral discretion, which is so vast. But the way in which you find that equipoise is no different from the answer to your question. How do we control the subject matter of the discussions in the terms of engagement? Through the memorials. Thank you.
I think it was our last question, so we thank a lot Pedro Martinez Fraga for the marvelous conference, and I hope we can meet in the future again here in Rome or somewhere else, of course. Thank you.
Consider my offer.